And that moves us on to number 11 on the action agenda, which is action as necessary or appropriate on matters discussed in executive session. Mr. Hogan.
I'd like to make the motion that the board approve selected employment items shown in Exhibit A.
Do I have a second? Mr. Satterfield. Any discussion? I'll call for the question. All in favor? That motion carries 7-0. And that goes to, brings us to number 12, which is the superintendent's annual performance review. And do you have a motion?
I've got one more for executive session under C, Employee Agreements Appeal.
Oh, sorry. Yep.
Yeah, I'd like to make the motion that the board grant the employee grievance to be heard by the board at the next convenient board meeting to be scheduled.
Do I have a second?
Second.
Ms. Huddle? Any discussion? All right, I'll call for the vote. All in favor of Mr. Hogan's motion? All opposed? All right, that motion carries 6-1. And now that brings us to item 12, the superintendent's annual performance review and formal statement by the board. Do I have any motions?
Madam Chair, after reviewing Dr. Ross's evaluation and considering the board members' comments regarding Dr. Ross's performance, I move that we conclude as a board that Dr. Ross receive an overall effective evaluation for the 22-23 school year.
Do I have a second? Mr. Hogan, any discussion? Seeing none, I'll call for the vote. All in favor? All opposed? All right, so that motion carries 5 and 2 abstentions.
Madam Chair?
Yes, ma'am.
I'd like to further move that as a result of Dr. Ross's overall effective evaluation, we extend his contract by 1 year through June 30th, 2027, and that we issue a statement regarding his evaluation.
A second? All right, any discussion? All in favor? All opposed? All right, that motion carries 5, 1 opposed, and 1 abstention. And based on that motion, the board has a draft statement that I'll read, or has a statement that I'll read. At our board meetings on June 12th and this evening, the board met to evaluate Dr. Ross's performance during the past school year, and we met with Dr. Ross to discuss his evaluation. The board evaluated Dr. Ross's performance in 5 primary areas, including governance and board relations, community relations, staff relations, business and finance, and instructional leadership. We wish to commend Dr. Ross on his overall effective evaluation for the 2022-23 school year. We appreciate the ongoing leadership that he has provided to the district. Dr. Ross is a good communicator with the board, the district staff, and community. He is a people person with a big heart for children, and he considers the whole child. Dr. Ross continues to seek innovative ideas to provide additional value to our students and staff. He has the unique ability to adjust and pivot when needed. As a result of Dr. Ross's overall effective evaluation, the board voted to extend his contract 1 year through June 30th, 2027. We appreciate Dr. Ross's exceptional leadership and commitment to the district and the leadership he will continue to provide to the district. Thank you, Dr. Ross. That moves us to item 13 on the action agenda, which is the second and final reading of the proposed new board policy, GCCA, GDCA, Paid Parental Leave, Exhibit F.
Thank you, Madam Chair, members of the board, and our community. This brings us to second and final reading of our board policy regarding paid parental leave. Just as a reminder that this actually by state statute goes into effect today. And so we're here at second reading. We have by law 2 decisions to make. The first one is that who is eligible. So the school districts must decide who are the eligible employees for this benefit. This can be employees defined as certified, or it can be those who are certified and classified. It is the administrative recommendation that we include both certified and classified for this benefit. The second part of the statute that we must consider is the period of parental paid leave. And so we have two options, option A and option B. And so I wanted to go over these particular options. Option A would include the subsequent contractual term. Option B would not include the subsequent contractual term. And why is this important? This is important because when we look at this benefit for state employees, many state employees are not 190-day employees as teachers. So we have to convert this over to the 190-day contract. So if I was to look at option B first, the term would be defined by that previous summer, starting today, June 26th through August 6th, and the beginning of school, August 7th through May 31st. That would be the defined benefit period under option B. If the event or the qualifying event was May 20th, that employee, that eligible employee, would only receive 2 weeks of paid family leave under the option B. Under option A, if we look at that, the term would have the subsequent contractual term. So in that same instance where the qualifying event was May 20th, that employee, eligible employee, would receive 2 weeks of paid family leave, and at the beginning of the next contractual term, receive the remaining 4 weeks. So under option A, 6 weeks or 6 weeks for a full-time employee. If it's a part-time employee, a 0.5 FTE, then it would be 3 weeks. But you have the full benefit of 6 weeks no matter when the qualifying event occurred. So, as a result of Section Code of Laws 811-151, the administration recommends option A, that this would work through subsequent contractual terms. So that, Madam Chair, members of the board, we have for a second and final reading those two decisions for our paid parental leave, and we stand for any questions.
Do we have a motion or Ms. Kimberly Snipes?
Madam Chair, I make a motion that the board approve the second and final reading of the proposed new board policy, GCCA, GDCA, paid parental leave, option A, and completely implement the provisions of the act effective June 26, 2023.
Finish the motion.
The administration recommends that the final version of the policy allow ineligible district employees entitlement to leave under this policy to extend beyond their designated term of employment for their contractual term, allowing the employee to continue their period of paid parental leave in subsequent contractual terms, provided the employee remains an eligible district employee.
Do I have a second? Mr. Hogan, any conversation? Ms. Huddle?
I have a question. Dr. Ross, could somebody, I'm just a little worried that someone would, let's say, be out 2 weeks before summer and then they have 4 weeks left, and they could be intending really not to come back. Could they tell you that so they could get their 4 weeks of leave, and thereby we would get kind of a heads up that we would need to fill that position?
Dr. Turner?
The leave would still be relevant, so they would be entitled to leave. That would be the rule, and we would treat it just as we would FMLA and any other type of leave. So they would be granted the leave that they're entitled to.
So they would not be penalized for letting us know in advance? Like they could say, I intend to resign, September 20th or something like that?
No, ma'am.
Okay.
There would be no penalty for that.
Thank you.
Any more questions, conversation? Seeing none, I'll call for the question. All in favor of this motion? I see that motion carries 7-0. And that brings us to our discussion agenda, item 14, which is the discussion of district attorney listings for 2023, 2024 Exhibit G. Dr. Ross?
Yes, we have a discussion item on our legal services. I'm going to ask Ms. Paul to come forward and discuss our legal services.
Thank you. Good evening again, Madam Chair, members of the board, and Dr. Ross. Tonight, I'll speak to you about legal services. So Board Policy BDG governs legal services, and then Board Policy BDG Administrative Rule also states that the board will approve the attorney listing at least annually. So this is just for discussion tonight, so not for action until a later meeting. But you do have in front of you the list of all of the attorneys that the district currently uses. This is the list that was approved last year. This list has not changed. We have not added any or deleted any firms from this list since the last time that you approved it. But I will be glad to take any questions that you may have.
Do we have any questions? Ms. Huddle?
Not a question, but I sent everyone on the board, the policy was modified after that last list was created, specifically to make it very clear that the list was going to be individual attorneys and not firms. So I think before the next meeting, we need the administration to list out the actual attorneys. I mean, you could put their firms in parentheses or something. And then the other thing was, I don't think a minimum score was required, but the board was also, per policy, going to look at, I believe it's the Martindale-Hubbell score. So that's another piece of information I think we'll need.
Do I have Mr.?
Yeah, I had a question. Ms. Huddle, with the individual attorneys, what would happen if, let's say that Dr. Ross or somebody needed to get in touch with somebody who was on vacation? I mean, if there was something that was very pressing, what are your alternatives, Dr. Ross? If somebody's not readily available or in court, or, because right now I'm dealing with an estate planning issue, and my attorney's been in court for 2 weeks straight. So I'm just curious, do you have alternatives?
I appreciate the opportunity for clarification. We interpret it differently. We've interpreted, so we need clarification of the board on what is the intent. We engage with firms. So when we're engaged with a firm with the legal matter, if the lead attorney is out, then we go to whoever that partner is with the firm. We do know that for adding someone to, as I read the policy, is that if we're going to add someone to that policy, the way I read it is that we provide the names, the scores, all under the procurement process. But for the annual review, I did not read it as we had to have individual names and scores for each person on all of those firms. So if that's the view of the board, we will definitely do so.
I know that this policy was modified in May of last year, and I kind of had some questions on how that works, just based off of like the nature of how law firms and work within, you know, if they have an associate doing research or helping out, if a partner does, I mean, that could be an issue. But what I took it as is that, say you have Joe Smith Law Firm, and they have 4 attorneys that work at that firm, that you would list each of those attorneys on the list. And if there came to be an issue that, you know, one attorney, you know, I don't know. I mean, I mean, one attorney wouldn't meet the qualifications and they wouldn't be put on the list. I see pros and cons to this policy, and I have the same questions about how the administration and the board would be limited if there were to be an associate that wasn't on this list doing work, because associates turnover in law firms relatively, I mean, they turn over more than like a partner would frequently. I was blanking on the word, sorry. So, I mean, that's my,
I have an answer for that.
Yeah.
The policy allows the board's attorney to use other attorneys as needed. And I believe that was expressly why that was in there, so that if that situation arises. But there is absolutely no doubt that the policy says attorneys. It does not say firms. And if you go back and you look at what the policy was and how it was changed, it was intentional for it to say attorneys and not firms. If you will recall, we had 2 instances where we got attorneys involved in stuff that were not the attorney. They were part of the firm, but they weren't the attorney we thought we were getting. And I think that's one of the reasons that led to this. But, I mean, I think if you're concerned that there's not enough choice, like you said, Ms. Blackburn-Hines, list out all the attorneys. But if you don't do that, you have some firms that have hundreds of employees, or lawyers, I should say. So if we want to change the policy, let's change the policy. But the policy does not say firms, it says attorneys. And you can go back and look at how it was changed.
well, I think listing the attorneys out that would be the likely attorneys to handle, these, school board or school district related matters, is a fair assessment. I mean, because then and if there is a situation where an associate is, a new associate before a list can be updated and our board attorney can, provide clarification to the board on that, and that's a good thing. I mean, that's my thoughts. Mr. Scully.
I can't say that I really have strong feelings either way on that, but my question would be more about consistency with other policies. Are other approved vendors that same way, or would this be an outlier?
Attorneys are a little bit unique in the way that they operate with staffing. I would say it's not like the same as a construction firm or a computer firm that you're working with. It's not the same kind of
It's
thing.
a 710 exemption, so if you look in the
Yeah.
procurement code, there's 710 exemptions. It's the only one, Ms. Paul can correct me if I'm wrong, but I believe it's the only one where there is a list of available. All the other 710 exemptions are the district can choose whoever they want, I think.
I would have to go back and check that. I'm not sure offhand.
And I would just just for, as we move forward with this and, when we bring this for action and after that period of time, if there are significant issues faced by the administration, I think that that's important to provide that feedback to the board. But we haven't really had enough time to really see how that plays out. And I think at this point, I don't know how how it looks. If you know who the attorneys are at, a certain law firm that you can list out, or if that do we need to reissue or
I mean, we could
qualifications?
certainly just look at our invoices and see, what attorneys we have worked with over the past year, 2 years, however far we want to go back, and we could list those for y'all, if that's helpful, or if y'all think we need to do a full RFP. We're not adding, I don't believe we're adding anyone.
Right.
So I guess we could do either way. But if you just want us to look back at the invoices and see who we have used, who has, from these listed firms, who has been listed on the invoices, we could certainly provide that information.
I think that would be helpful before we, approve anything.
I just want
Dr. Ross.
clarification for the administration. As I read the policy, it says the board will select attorneys based on qualifications submitted from interested firms. These are submitted, from my understanding, from an RFP, or a request for proposal. So the outline of the score and the peer review ratings, the license, all of this we were doing as a function of a request for proposal. is this being requested for every attorney that we've worked with from all of our firms?
Yeah, that was the other thing that was changed, because in the past, I think it was sometimes, I don't know if it was a formal RFQ, but it was sent out, and that was another policy change, was to send a letter or out to interested attorneys and ask them if they want to be on the list, because it's been hodgepodge in the past.
So for clarification, we're to do a request for proposal for all of the attorneys?
Do we need to do that, or do we just need to send a letter to our existing firm saying, can you verify this information for us? I mean, to me, that would be the easiest way to, without having to reissue. And if you can find the attorney, if you know the attorneys that we work with that are already on this list, then you can send that information to them, and they can, I mean, these should be fairly straightforward questions from any attorney from one of these firms, I would think.
I think we can definitely look at the list, and if you want us to send out a letter as well, it just says that the need to do an RFP is when any additions to the list require full board approval following the submission of an RFP. So if we're not adding any,
Right,
then I would think we could just list them on.
right. Mr. Scully?
Yeah, and again, I don't have any strong feelings on this, but I'm worried that would this be creating any unnecessary red tape or paperwork? I mean, if the attorneys have the ability, as Ms. Huddle said, to delegate it essentially to other attorneys or anyone else in the firm, how is that different than just approving the firm? Like, what, do they have to tell us? I mean, what kind of paperwork? How do we know if they do that or don't, what's the procedure there, and is that going to be onerous?
It's only the one board attorney, so, and right now, Mr. Bradley is the board attorney. So if someone was needed that wasn't on the list, Mr. Bradley could bring them in, and he's the only one.
Does that
by the
apply to
policy.
just like,
I mean, let's
rather
say-
than just coming, but just work and research and things like
So
that?
say
or-
there's an employee matter, and the district is working with a firm to handle the employee matter, and the partner wants to delegate to a subordinate that's a new attorney to the firm. I would take it as the administration would talk to Ward, and Mr. Bradley would reach out to the firm and basically just make sure that we know about it, we're aware of it, and everything is okay. And, I mean,
Yeah, I'm just trying to think forward, like, for future
and
audits down the
honestly,
road.
we
Would
haven't
that be
actually had
creating
to
any kind
implement
of?
this, so there could be some ambiguities we don't know about. That's why I
And I
was
think the
saying,
intent of it was something weird happened, like, let's say somebody fell out of a tree, and there's an attorney that specializes in people falling out of trees. I mean, that's a
Right.
crazy example, but that was really why that was put in there. But it could also be used that somebody's just not available.
Right.
But it was really just because there might be an area of expertise that's not on our list.
right.
Okay.
Any more discussion on this? Dr. Ross, do you need any more clarification? Or Matt?
Ms.
Ms.
Paul?
Paul?
I guess in July, we will bring back to you a list of all of the attorneys that are, we already have the firm, so a list of all of the attorneys that are in these firms that we have used in the past year, to however far we need to go back. And then y'all at that time would approve in July.
Right, yeah, right. Just
I guess
making
would
sure
y'all
that we've
go
reached out
through
to them for these qualifications, just to
Okay.
make sure everything is on the up and up. And and as long as you've gotten the response back. If you don't get the response back in July because people are on, this is a very weird time of year, so, I mean, I would, unless there is, somebody has a differing opinion, and, I mean, that's,
Okay, do we need to provide the Martindale-Hubble peer review rating for each of these attorneys?
I think that's a very interesting qualification, because I don't know that everybody participates in that program, but it is in the policy, so I would just probably, if they have it, and if they don't, notate that they don't, and then we can discuss it at that time. I'm not trying to overstep, so if anybody disagrees
Well,
with
if you're
me, just.
asking them for a list, you could ask them to provide the
Right,
rating.
right.
And I don't think the policy precludes you from selecting someone. I think again, the idea was, we want a seasoned attorney, not, and especially in certain situations, not necessarily someone who just graduated kind of thing.
Right, but those folks are going to be overseen by a part, typically what we see is the partner is the one actually providing the information, but research or administrative stuff may happen, so. Just my thoughts.
We can do that.
All right, thank you, Madison, or Ms. Paul.
Still here.
All right, so that moves us to number 15 on our discussion agenda, which is the discussion of selection of procurement review panel, Exhibit H.
Ms. Paul?
Yes, so you'll have before you a memo regarding the procurement review panel. This is governed from our procurement code in section 4410. This talks about the creation of the panel and the reasons why the panel may be needed. I did discuss this with an attorney, and the way that he kind of described this panel is more of like a court of appeals. So basically the process for protest, debarment, any issues when it comes to contracts, all of that would come through me. So I am considered the chief business official for the district, as well as the chief procurement officer. So any of those requests, again, for protests, anything like that, would first come through me as the chief business official. I would then make a written determination, and then that determination could then be appealed by the affected party. So this is, this has been in our new code since April of 2022. This is similar to what was in our old code as well in the past 7 years. Since our procurement coordinator has been here, this has only risen to this level one time. So this is really on an as-needed basis. So at this time, this is just for discussion, but there are some items that we'll need to take action on by the board at some time, whether that's today or at the July 17th meeting. But it does talk about the membership and who is composed of this review panel. This panel is chaired by a member of the board. So that would be a vote by the Board of Trustees. And then additionally, there are 4 additional members of this board. These additional persons are appointed by the board chair, the vice chair, the superintendent, and the chief business official. So there are some guidelines about who these members should be, really just members of the community who are well respected and have knowledge in the areas of procurement, and that the term runs from July 1 through June 30th annually. And again, at this point, it's just on an as-needed basis, but we do feel that it is important to go ahead and establish this committee for the new fiscal year.
I have a question regarding this policy and when it is established and whether or not it has to be. I see that you may not have to have a standing procurement review panel. And I feel like the last one that we had, there was some, like, when there was a situation that came up that for potential review, there could have been like a conflict of interest because a board member was a chair, and then I think their job related to whatever the subject matter was. So I guess I question whether or not we establish this before a situation occurs, because if there is if a situation arises where somebody may have a conflict because of a current or previous job or something like that, then you kind of have to restart the process.
I'm sorry. I will just note, so there's a drafting note actually from the state procurement board, because they, of course, they reviewed our procurement code, made sure that it complied with the state code, and there's a note that it says, districts may not have a standing procurement review panel. So basically, the change that they suggested was that everything goes to the chief business official, so that there's always somebody on staff to receive any protests, any issues, anything like that, to make those written determinations. And then if it rises to the level that basically it is appealed at that point, then you could establish the procurement review panel at that time. I did discuss that with the attorney as well, and he said we could really do either way. But this is our new, relatively new procurement code. It's only been in place about 1.5 years, truly been effective for the past school year. So it would be up to the board whether y'all wanted to truly establish it for the entire fiscal year, or if you wanted to establish it when it was needed.
Okay. Do I have any questions? Ms. Huddle?
So if we did it for the remainder of the year, for example, that wouldn't be considered permanent, so we would be okay. Would it help you in terms of how quickly do we need to put a committee together to have kind of a committee already fleshed out?
Yeah, so there are definitely guidelines for that timeline. So in Section B, it says that requests for review must be submitted to the chief business official within 15 days, and then the committee must convene. Can't find it, but I believe it must convene within 15 days after the written response. So after that appeal, the committee must convene within 15 days.
Okay, so I guess the question that I would, we just can kind of decide, I mean, this is on the discussion agenda, so we're not taking action on this tonight, but if we want to make a determination on this, we should put it on the action agenda at the next meeting. Okay. I guess, what I would ask the board, because we're not really taking a vote, I don't know. I mean, I guess, do we want to put it on the action agenda for next meeting, or do we want to just let it lay? I mean, I don't know. I mean,
I got a question
Dr.
for Ms.
Ross?
Paul.
Our recommendation is that, the way we read this is that in the event there's a protest of any procurement item, and they call upon the review panel, we should have that already in place.
Okay.
So I would think that the best thing is close to July 1, we have a chair of that panel from one of the board members. That you nominate a chair, and then as expressed in the policy, we would send the chair, the vice chair, the superintendent, the CFO would send names of community members from the different procurement areas to that chair of that panel. And in the event there's a protest of any procurement item, we would already be established. And so that's something that they're only called if there's a protest, correct?
Yes, if there's a protest or if there is let me read, because it's 4210, 4220, and 4230 are the code sections of the procurement code. So 4210 is regarding protests, 4220 is regarding debarment or suspension. So that would be a written response from a written notice from me that we are debarring or suspending someone or a vendor, and then they would have the ability to appeal. Again, the first level of appeal comes to me, and then I would make a written determination for that appeal, and then then it could go further to the procurement panel. And then the third section is regarding contracts and breach of contract controversies. So again, all of those would be written determinations from the chief business official. And if there is an appeal, the appeal would come directly to me first. If it cannot be resolved at that level, that is when it goes to the procurement review panel. And again, we've seen in the past that's happened one time in 7 years. So it's not a committee that would convene very often, we don't think.
Right. So we could put this on the action agenda for the next meeting.
That would be our recommendation
Okay.
with, I'm sorry.
Mr. Scully?
Yeah, I'm not sure what the outcome's going to be, but if we do have this panel, I would like to nominate me for chair of the panel.
Okay. Mr. Hogan?
Ms. Paul, with the members from the community that would be selected to serve on this panel, just for us to help us navigate through asking those questions, obviously it's going to be something they would be called upon, so that wouldn't be anything they would have to schedule their time to appear on a routine basis. But is it just the conversation saying, would you serve on this, wait to hear from the district, or?
Yes, pretty much, again, we don't expect them to convene very often.
Okay.
So, it would certainly be, are you willing to serve in this capacity? This is what this looks like. You could give them some history of, again, we've had this committee convene one time in the past 7 years. And then I would request that you would send your appointment to me, just so that I have record of all of those appointments between the four of us. And of course, I would send that on to whoever becomes the chair. But we would just want to make sure that we have record of all of the appointees.
Perfect.
Mr. Satterfield, did you have a question?
Yes, ma'am. I'm trying to read this as I listen to Ms. Paul there, giving a clear explanation. Now, this is more of a procedural question. So if somebody in the community questions something with regard to procurement, they fill out a form, much like they would if they were contesting a book, right? And they write down their concerns. And does every concern does result in the committee getting together? Or is this something where the chairman or somebody makes a determination whether or not this goes forward?
That's a great question. Ms. Paul, you want to clarify?
Yeah, so if you look at, and I know you don't have it in front of you, but Section 4210, which is the right to protest, it has to be someone who is aggrieved in connection with the solicitation. So this would be a prospective bidder, an offerer, a contractor, or some subcontractor who is aggrieved in connection with the solicitation shall protest to the chief business official within 15 days. So you have to be impacted by the award, by the solicitation, by the process, something like that.
Oh, I see.
So that's the very, kind of minimum, is that you have to be someone that is a party to the action.
So somebody just said, I disagree, I understand there's an erroneous invoice and all that, now you have to gather these people from their jobs and bring them together, but it's somebody who is adversely affected by the process.
Yes, sir. And if
Okay.
there are any other, questions concerning the process, all of those, again, would go to the chief business official and would of course, try to be resolved at the administrative level.
Sure.
Prior to going to any further action of the panel.
Thank you.
Yes, sir.
All right, any other discussion of this, Ms. Huddle?
I just thought it might help to explain kind of what happened the last time. We didn't have a standing committee, and somebody did protest. I think it was an insurance company. And I think Matt and Mr. Hogan and I both knew them. So that's why we didn't do it. So that's the only challenge, is you could put the committee together and they don't know which vendors may complain, and if a vendor complains, you may have to replace a committee member if they know that person.
And I think that was kind of I remembered that there was an insurance issue with the last one, so we had to go through like half the board to even get a chair for the committee, which is why I was wondering whether, we should wait until we knew what the matter was. But I mean, that's just my, I don't have a strong opinion either way on that. I just remember that being an issue.
I doubt it would happen again. I think it was just.
Don't say that, it will.
Well, I shouldn't say that, knock on wood. I think it was just, it just so happened that Matt and I have both been in insurance before and knew them. But most of the things the district buys are school-related, so I would be optimistic that everyone would be fine.
Okay. All right, so any other discussion for this item? All right, seeing none, thank you, Ms. Paul, very much. Seeing none, that takes us to the next item on our discussion agenda, which is the discussion of proposed revisions to Board Policy GCQE, Retirement of Professional Staff, Exhibit I.
Madam Chair, with your permission, we would like to do both items 16 and 17, as they're very similar.
Any objections to that? I don't see any. Okay, go ahead.
All right, Dr. Turner.
All right, good evening, Board Chair Hines, members of the board, and Dr. Ross. The discussion items for 16 and 17 for Exhibit I and J, I do want to make a correction to what was submitted. The agenda says it's the discussion of proposed revisions. Your handouts may say it's discussion and first reading, but this is just the discussion, so my recommendation will be based on this just being the discussion. Periodically, we get notifications from the South Carolina School Board Association, and they provide reminders to us about where we need to look at policies to update them. This is relevant for these two proposed revisions. To provide some context, our current policies, GCQE and GDQC, retirement of professional staff and retirement of support staff, we still have the language that references the Terry program. And that Terry program was repealed in 2012 and officially took effect in July 1st, 2018. So the proposed revisions is that we update our two policies to remove that language about Terry. So the administration for both of these exhibits I and J, we recommend the board move to the first reading approval of both these policies at the July 17th board meeting.
Do we have any questions relating to this policy? All right, thank you, Dr. Turner. All right.
Thank you.
Thank you very much. And that leads us to number 18 on our agenda, correct? Yes. All right, do I have a motion, Mr. Hogan?
I'd like to make the motion that we adjourn the meeting.
Have a second?
I'll second.
I heard Ms. Barnhart. Any discussion about this motion? All right, seeing none, I'll call for the vote. Motion carries 7-0. Meeting adjourned.